All right, quickly just bring back in session the Honorable James Dudley Simpson presiding.
May be seated. Yep.
I call you.
Yeah, you can call. Host disabled. Yeah, we can bring her on. Got it. Got it. He calls the cases of the people versus Vincent. Counsel as well as the defendant is present. With reference to the cases, the court is going to start and going to go in reverse order. In case 25 FB 1002, defendant in that case is charged with 3 counts that the people are proceeding on: the carrying of a dangerous weapon with lawful intent, the possession of a firearm by a prohibited person, actually 2 counts of that. Given the stipulation that there is the predicate counts that would make Ms. Vincent a prohibited person, and also given the testimony, the court would find that the people have sustained their burden and would bind the defendant over, in that case, on all 3 counts.
Some lie loudly, some lie with tears. Some hide behind legal jargon. But no matter how polished, lies decay fast under cross-examination, and the first crack is always in the voice.
Count 4 as the people are not proceeding on that count. With reference to case 25 FB 1003, given the testimony in the case of the firearm being found on the defendant in her armpit, as well as the testimony of Deputy Bechtel regarding his participation in attempting to get the defendant to comply with what this court views as reasonable and lawful requests of police officers, obstructing the search as well as the detention of herself at the time. And while I note that part of defense's arguments was maybe that there was not a lawful reason to arrest, the court does believe that the testimony in this case did show that there was information coming to the Washtenaw County Sheriff's Office and those deputies, as well as other law enforcement, regarding the shooting that had occurred in Northfield Township. And so for those reasons, and the fact of the presence of the officers, her inability to cooperate with them, the court would find that the people have sustained their burden, and on that case would bind the defendant over on all 5 charges in that case. With reference to the, I'll call it the primary case, but 25F 30011, given the testimony, and if I may state, just given the testimony of Mr. Bernhardt, will say that I find his, not only his testimony incredibly compelling, but he is amazing in a lot of ways, and quite frankly, only through God's grace could have been here even to testify in this case. But given that, certainly, and what he saw and what he testified to, as well as the defendant's admissions in the testimony of the officers, the court would bind the defendant over to stand trial on the count of open murder, count 1 regarding Jennifer Bernhardt, as well as on count 2, the open murder charge regarding Stevie Smith. With count 3, with the assault with intent to murder, it's very clear that Mr. Bernhardt's testimony showed the actions of the defendant regarding his attempts to kill him. And the people have shown sufficient evidence by probable cause to bind the defendant over on count 3. With regard to the issue of home invasion, the primary objection of the defendant to those charges, certainly the predicate of the defendant's actions and what offenses they did on the premises once entering the home.
The judge doesn't yell to control the room. They don't need to. A single pause, a quiet stare, that's enough to make even the toughest attorney stumble. Silence is the most dangerous weapon in the courtroom because it forces everyone to listen to themselves.
Are clearly established by this record and the testimony in this case. The issue is really whether or not they entered whether or not the defendant, as well as the other 2 individuals, entered the premises with permission. It seems to the court that, frankly, I think I could just diminish that by just indicating that that may be an issue of fact as to whether or not they entered the premises with permission, and that is something that would need to be tried by the trier of fact, and therefore would bind it over on that basis. However, I think there's a lot more here, certainly circumstantial, that would lead an individual to conclude that these individuals did not enter the premises with permission. One of the things is at the time that there are supervised visitations, so that the defendant shouldn't have been at the premises, entering the premises to see True. That's one. The other thing was Miss Bernhardt exclamations, her screaming, and as Mr. Bernhardt described, that they were not just screams. Let me put it this way. He distinguished between the screams of the young girls and their noise that they may make from that of his wife, which was of some fear and the like. It would, in this court's mind, be unlikely that an individual exclaiming in that fashion would have been able to, or would have granted permission for this individual to enter their premises, in particular, given some of the angst regarding the foster care regarding True. So while I note defendant's objection regarding that issue, the court doesn't believe that it is substantial. And I think, quite frankly, the evidence in this case leads in the other direction, that there was no permission that would have been granted. And so for those reasons, the court would bind the defendant over on the charge of home invasion in the first degree, that being count 4. There are then 2 counts, counts 5 and 6, which are the kidnapping, child enticement. Defense counsel makes the argument regarding the issue of intent to deprive the parents or lawful caregivers of the child. And I say this respectfully, it's kind of a bizarre argument. I understand why counsel's making the argument, but first of all, I don't think his argument would be applicable to Olivia if the issue was not the intent to deprive, but the intent to provide some safety for True. But True was lawfully placed in the possession of the Bernhardts under the auspices of a court having jurisdiction to do so, that Miss Vincent then goes there to take the child. If one were to say that her intent was not to deprive the parent or lawful caregivers, then this statute would not make any sense, because what individuals could then do is precisely what Ms. Vincent did, but was unsuccessful in one regard to Mr. Bernhardt, is they could go.
Tick. Paper shuffle. Tick. The bailiff's stare doesn't move. Every sound in this room means something. The prosecution sigh. The defense's pen tap. The jurors cough. They all form a rhythm. The rhythm of power. In this room, every second decides whether the truth survives the day.
The child, kill the parents, and then I would not be guilty of this offense because the parents are no longer living. It would be clear, and I think in one of the things that the court looked at, that she cannot, even if that argument were one that could be made, she is the wrongdoer and cannot benefit by her wrongdoing to escape criminal liability. So for those reasons, the court would also bind the defendant over as charged on count 5 and 6 of kidnapping, child enticement. Also, with reference to the conspiracy charges as contained in count 7, count 8, count 9, which are the conspiracy to commit murder, commit homicide on the open murder, and the conspiracy to commit home invasion, and the conspiracy to commit kidnapping. There is clear testimony on this record that there were 2 other individuals that were there who clearly, at least in this court's mind, but certainly at worst for the people would be an issue in question of fact, did conspire to commit all of the offenses, which I have now bound the defendant over on. There is also then, so I would find that people have sustained their burden as to count 7, 8, and 9, as well as count 10, the felony firearm. With that, and noting that that charge is properly stated with regard to her possession of the firearm, and notably that firearm is linked, that she was ultimately caught with, is linked to the casings and firearms that were used at this double homicide. The court would find that the people have sustained their burden as to count 10. With regard to the request to add count 11, the armed robbery, an offense punishable by any number of years up to and including life, the court would indicate that the people have also sustained their burden and the proofs do meet out the adding of the charge of armed robbery, specifically with reference to entering the premises while armed. And I mean, I guess in some respects, what makes this case so sickening is it wasn't just about True. It was about then going into the house and just creating mayhem and then taking the individual's monies, the father-in-law taking and having his checks, and then selling money from the credit card and taking time to do that, likely prior to the time of simply put, just executing these individuals. And so the court does believe that the people have sustained their burden and would add the count 11 and bind the defendant over on count 11. So in summary, on that case, the court is binding the defendant over on all 11 counts to stand trial. Thank you. Mr. Johnson, with reference to the reading, do you waive presentation, reading of the complaints in this case?
Yes, Your Honor.
And how does your client wish to plead?
I'm not guilty.
All right. Defendant having waived formal reading of the complaint and presentation, court will enter the not guilty pleas as to all counts. Pretrial in this matter will be set for
October 1st at 1:30 with Judge Conlon.
October 1st, 2025, 1:30 before Judge Conlon. I may take a bit of personal privilege. I'm sure those have heard about Judge Conlon, and this judge certainly has been keeping up with that, and will wish my colleague and friend all the best in the world. All right. Bond will continue in this case as denied. Thank you.
Thank you, Reverend.
October 1.